Antes de pasar a la siguiente panelista, quería hacerles notar que el comité organizador me avisó que la pausa del café la vamos a dejar para el final, en atención a que estamos bastante atrasados en el tiempo. Así que, a continuación, la abogada y miembro suplente de la Comisión de Venecia en representación de Irlanda, señora Grain McMorrow. Bueno, ella es abogada y profesora de Derecho de la National University of Ireland, Galway. Ha participado en diversas comisiones, tales como la Comisión de la Ley de Salud Mental en Reino Unido, Comisión de Salud Mental y Revisión en Tribunales de Irlanda, además de ser asesora del gobierno británico en la redacción de legislación de salud mental en 1997 y 1998.
Buenos días a todos. President Carmona, distinguished guests and friends, thank you for this opportunity to share some reflections on the protection of minorities and indigenous peoples in the case law of the European Court of Human Rights. Apart from extending my greetings to you from the Venice Commission, can I take a moment to extend greetings from Ireland, where I come from? A very small island, very far away, with a small population of only 4.5 million, but yet we seem to have populated the world. I have met so many of you today who have some Irish ancestry, and I find this fascinating. Now, we were never a colonial power, but we appear to have colonized the earth by stealth. So perhaps I should start with an apology on behalf of my countrymen. And I sincerely hope that our contribution to your respective countries has been positive overall. Can I ask you to bear with me on this enormous and important topic, to reflect a little on the context? Minorities have been described as a group numerically inferior to the rest of the population of a state, who are in a non-dominant position and whose members, being nationals of the state, possess ethnic, religious, or linguistic characteristics differing from those of the rest of the population, and show, if only implicitly, a sense of solidarity directed towards preserving their culture, traditions, religion, or language. Now, indigenous peoples are peoples who inhabited a land before it was conquered by other people or societies during colonization, by force or by treaty, and who considered themselves distinct from the society currently governing those territories. They form at present non-dominant sectors of society and are determined to preserve, develop, and transmit to future generations their ancestral territories and their ethnic identity as the basis of their continued existence as people, in accordance with their own cultural patterns, social institutions, and legal system. Now, the status as an indigenous people is more advantageous than designation as a minority. And indigenous people have therefore sought to distinguish themselves from minorities. The status of indigenous people cannot necessarily be treated as part of the protection of minorities, because indigenous populations may even constitute the majority in a state. for example, as a non-dominant majority, as in Bolivia, or a dominant majority, as in Fiji, or in former times in South Africa. Still, however, there is no accepted universal definition. Now, the Indian communities in the USA, the Inuit in Canada, or the Aborigines in Australia are seen as indigenous people in this sense, who have and still are effectively suffering prosecution and discrimination at the hands of their invaders. An indigenous people may be a minority, but it is not necessarily a national minority, because the territory of settlement may not be identical with the state frontiers. As a consequence, such indigenous people can only rely on minority rights if its role as a minority is accepted. The crucial point of the rights of indigenous peoples is their capacity for claiming the right to self-determination. If they are attributed this capacity, they would be entitled to put forward rights of autonomy, entailing the danger of secession. Now, the standard of protection of indigenous peoples is based on a combination of legal instruments and customary international law. The protection of indigenous peoples is essentially a problem of striving for exclusion and preventing inclusion, assimilation, or integration. Whereas the problem of minorities is very often a problem of striving for inclusion and preventing exclusion. There is no international or European consensus on the definition of a national minority. It is a sensitive issue, as the term would often be associated with secessionist claims or demands for independence. Given the political difficulties, the European Court of Human Rights has avoided giving such a definition and instead prefers to leave it to the state. Now, the lack of a legal definition allows member states to have a relatively large margin of appreciation in selecting the minorities for which they want to provide legal protection. Issues of minorities that come before the European Court of Human Rights are largely concerned with linguistic rights and freedom of expression under Article 10, education of children under Article 2, Protocol 1, freedom of religion, Article 9, and the right to participate effectively in cultural, religious, social, economic, and public life, Articles 11 and Protocol 1 and Article 3. And of course, with respect to the right to respect for private and family life in Article 8. While it is beyond the scope of this paper to discuss all of the case law relating to minorities, I will, however, endeavour to address some areas of significant interest. Now, the question of vulnerability is very important, and this has been described as a universal, inevitable, enduring aspect of the human condition, which encompasses the notion of minority groups. The European Court of Human Rights recognizes the existence of particularly vulnerable groups and not only takes into account belonging to a minority, but also the existence of a history of prejudice and stigmatization. The concept of vulnerable groups was first introduced in the case of Chapman versus the United Kingdom in 2001. And this concerned the Roma minority. In Europe, the Roma community is the largest and one of the most vulnerable minority groups, with 10 to 12 million living in the European Union. They suffer a wide range of human rights violations, and evidence has clearly shown that they are more likely to face discrimination and social exclusion than others living in Europe. Now, while significant minority protection started under the Council of Europe in the 1990s, the most effective tool of protection is the European Court of Human Rights, and also with regard to the improvement of the status of minorities, and so it will be the focus of my remarks. The right to individual petition is inherent in the convention system, and all of the court's judgments are legally binding on state parties. All domestic remedies must have been exhausted by the applicant before an application is made to the European Court of Human Rights. Failure to appeal a case to the state's court of last resort may result in an application being declared inadmissible by the European Convention of Human Rights. Now, the convention system is premised on the principle of subsidiarity. And so if the applicant fails to exhaust all domestic remedies, the European Convention of Human Rights will conclude that the national legal system has been deprived of an opportunity to review the convention complaints. The rules of the convention system impose explicit and fairly demanding obligations upon national authorities to comply with the European Court of Human Rights adverse judgments. When a state is found to be in violation of one of the provisions of the Convention, national authorities are required to comply with the European Court of Human Rights judgment by undertaking both individual and general measures. And we've seen legislative amendments in more than 50% of the cases to rectify the particular injustice. However, the court has, for the most part, refrained from ordering the respondent state to undertake specific measures, taking the view that it is not empowered to do so by the Convention. So that once a judgment has been given, responsibility then passes to the to the Committee of Ministers of the Council of Europe to supervise its execution and to ensure that any compensation is paid. The European Convention on Human Rights does not include any specific provisions on minorities, although there are a number of rights guaranteed by the Convention that are relevant to them, such as the right to equal treatment and non-discrimination. It has been claimed that the European Court of Human Rights has become the protector of national minorities, and by requiring compliance with the principle of pluralist democracy, it provides de facto protection. Article 14, the General Non-Discrimination Clause, provides that the enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination on any ground, which includes association with a national minority. However, Article 14 is not a freestanding right to non-discrimination. and it can only be raised in connection with the alleged violation of another right under the European Convention of Human Rights. A new approach to Article 14 is emerging, in which there is concern over systematic discrimination and exclusion. In the famous case of Belgian linguistics, an old case from 1968, which had to decide on the use of minority languages in Belgium, the court confirmed that differential treatment of persons in similar situations is permissible if it rests on a reasonable and objective justification, if it pursues a legitimate aim and is proportionate to that aim. The jurisprudence of the European Court of Human Rights was revolutionized in 2007 in the case of DH and others versus the Czech Republic, when the Grand Chamber endorsed the notion of indirect discrimination, where apparently neutral laws or policies apply equally to everyone, but which have a disproportionate impact on one part of society. Also, for the first time, the European Court of Human Rights were prepared to accept statistical evidence to support the applicant's claim, although it was not essential in this case. Now, this case involved a disproportionate number of Roma pupils who were placed in special schools for children with mental disabilities without justification, and it was held to be in violation of the right to be free from racial discrimination under Article 14, read in conjunction with Article 2 of Protocol 1, the right to education. The Grand Chamber concluded that the selection tests were biased and did not take into account the special characteristics of Roma children, and that their parents were not in a position to give informed consent. In relation to the margin of appreciation of the national authorities, the Grand Chamber stated that the procedural safeguards available to the individual will be especially material in determining whether the respondent state has, when fixing the regulatory framework, remained within its margin of appreciation. The most significant elements of the European Court of Human Rights decision is the explicit prohibition of indirect discrimination and the shifting of the burden of proof from the applicant to the defendant state in proving that any difference in treatment is not discriminatory. Now, importantly, the court held that no intent to discriminate was required in cases in the areas of education, employment, or the provision of services. Similarly, in a more recent case of Ursus and others versus Croatia in 2010, the Grand Chamber reversed the Chamber's judgment, and it was held that the placement of applicants in Roma-only classes during their primary education had no objective and reasonable justification. The government claimed that the reason for this was the Roma students' lack of knowledge of the Croatian language. It was held that there was a violation of Article 14 in conjunction with Article 2 of Protocol 1, as the measure was disproportionate to the Roma community, and there were no adequate safeguards put in place by the school authorities to ensure the applicant's speedy process in acquiring an adequate command of the Croatian language to enable the applicants to move into mixed classes. This approach was reaffirmed in the case of Alajos Kiss versus Hungary in 2010. The further case of Horvath and Kiss versus Hungary in 2013 involved a complaint from two young men of Roma origin who complained that they were wrongly placed in a school for the mentally disabled due to their ethnic origin. A violation of Article 14, read in conjunction with Article 1 of Protocol 2, was found. It endorsed the reasoning in DH and others versus the Czech Republic. The court placed an extensive positive obligation on the state and highlighted that adequate safeguards were missing, which would have prevented Roma children from being mistakenly and systematically placed in special schools. It held that the state must demonstrate that the tests used and their application are capable of fairly and objectively determining the learning abilities of the applicants. In the case of Nechavo and others versus Bulgaria in 2005, the applicants alleged that their relatives had been killed in violation of Article 2, the right to life, as a result of deficient law and practice, which permitted the use of lethal force without absolute necessity. The Grand Chamber affirmed in substantial part the court's first ever finding of racial discrimination in breach of Article 14. The European Court of Human Rights established that the states have an obligation to investigate possible racist motives behind acts of violence. Applicants also complained that the authorities had failed to conduct an effective investigation into the deaths and alleged that prejudice and hostile attitudes towards people of Roma origin had played a decisive role in the events leading up to the shootings, compounded by the failure to carry out a meaningful investigation. The court found that there had been a violation of Article 2 in respect of the deaths and that there had been ineffective investigation into them, and a violation of Article 14 taken in conjunction with Article 2 in that the authorities failed to investigate the possible racist motives behind the events that led to the deaths. In cases of racial violence, the court requires special vigilance and a vigorous reaction. It is for this reason that the authorities must use all available means to combat racism and racist violence. Now, the burden of proving a violation of the Convention normally rests on the applicant. However, the court has stated in discrimination cases that the state shall partially bear the burden of proof and show that it has conducted adequate investigations, or that the difference in treatment is not discriminatory. In a large number of judgments concerning Articles 9, 10, and 11, the court recognizes the right of persons belonging to national minorities to freely express, individually or collectively, via political parties, religious organizations or associations, all sorts of identity-based demands, including demands which challenge the existing constitutional order or the territorial integrity of the state, as long as minority demands are not in themselves incompatible with democracy and should be expressed by lawful means. A number of cases concern these issues: Yazar, Karatas, Aksoy, and the People's Labour Party versus Turkey in 2002, and the Republican Party of Russia versus Russia in 2011. The jurisprudence of the European Court of Human Rights has been carefully progressive, and especially since 2000, the Court has made use of the substantive provisions of the European Convention on Human Rights in support of minority protection. largely when scrutinizing the margin of appreciation of a state. In Sideropoulos versus Greece in 1998, the court found a violation of Article 11 and made it clear that states may not forbid the application of registration of an association because it aims to promote the culture of a minority. Pluralism is essential in a democratic society where there must be recognition of and respect for diversity and the dynamics of traditions and of ethnic and cultural identities, and states must not interfere unless there is a pressing social need. The main goal is that pluralism, political, religious, and cultural, is allowed to flourish without undue interference. In a recent case, Sedgwick and Finke versus Bosnia and Herzegovina in 2009, under the Dayton Peace Accords, only Bosniaks, Croats, or Serbs were permitted to stand for election, to the exclusion of the 14 other national minorities in the country. The court made it clear that it rejects internal arrangements formally excluding minority groups from electoral processes. The European Convention, or the European Court of Human Rights, found violations of Article 14, read in conjunction with Article 3 of Protocol 1, the right to free election, and a violation of Article 1 of Protocol 12, the first ruling by the court under Protocol 12. Article 8, the right to privacy and family life, is another area where progress has recently been made by the European Court of Human Rights. In Chapman versus the United Kingdom in 2001, this was a case that involved an applicant who wished to live in a caravan on her plot of land in violation of planning regulations and had been subject to enforcement action. It effectively was not until this case in 2001 that the Grand Chamber confirmed the link between private and family life and minority identity, along with an emerging international consensus recognizing the special needs of minorities and an obligation to protect their security, identity, and lifestyle, not only for the purpose of safeguarding the interests of the minorities themselves, but to preserve the cultural diversity of value to the whole community. The court recognized the Roma community as a vulnerable minority and found that to an extent the state had a positive obligation to facilitate the gypsy way of life, deriving from Article 8. However, it was quick to dismiss extensive interpretations of this obligation, which would require states to provide Roma communities with an adequate number of suitably equipped caravan sites to support this. And this is supported also in subsequent case law. Now, due to a wide margin of appreciation afforded to the state, the European Court of Human Rights held that the enforcement action was proportionate and pursued the legitimate aim of protecting the rights of others through preservation of the environment, and found there had been no violation of Article 8 nor Article 1 of Protocol 1, the right to peaceful enjoyment of possessions. Now, the extent to which the European Court of Human Rights is willing to read positive obligations into relevant provisions as a way of limiting state discretion is difficult to measure, as the case law has reflected varying degrees of judicial intervention. In a similar case, Connors versus the United Kingdom in 2004, the court found a violation of Article 8. Here, the applicant and his family had lived lawfully on a local authority gypsy site for 13 years, but were now being evicted. Connors confirmed the case law in Chapman, but it did narrow the state's margin of appreciation by holding that the lack of judicial review of the eviction at issue was reflective of a more general and significant obstacles being faced by the Roma community in pursuing either a nomadic or more settled lifestyle. The main difference between these two cases is that in Connors, unlike Chapman, the applicant was lawfully on the site, which left the state with a narrower margin of appreciation to interfere. Now, the same line of reasoning was followed in Munoz-Diaz versus Spain in 2009, albeit in a non-discrimination context. This concerned the failure of the state to recognize the common law marriage often present in Roma communities. The applicant was refused a survivor's pension by the authorities in Spain on the grounds that her marriage, performed in accordance with Roma traditions, was never officially registered. The court did note that the applicant's husband had been covered by Social Security and he had supported the applicant and their children for the past 20 years. Moreover, the applicant believed in good faith that she was married, especially as official documents listed her as a spouse. Thus, the court concluded that it was disproportionate for the state to refuse to pay the survivor's pension. The recent case of Winterstein and others versus France in 2013 is a significant case which involved eviction proceedings brought against a number of applicants who, again, were members of the travelling community and who had been living on the same site for many years, between 5 and 35 years, on grounds that there was a breach of planning regulation. The court declared the classification of a place as one's home under Article 8 is independent from the question of lawfulness of the occupation under domestic law. A violation of Article 8 was found. The court noted the National Court's failure to take into account the lengthy period for which the applicants were settled, the municipal authorities' tolerance of the situation, the right to housing, the provisions of Article 3 and Article 8, and the court's case law. That was a case in which the court also referred to Yordanova and others versus Bulgaria, a 2012 case, which was factually similar, and where a breach of Article 8 was found. It also emphasised that numerous international and Council of Europe instruments stress the need, in the cases of eviction of Roma or travellers, to provide the parties concerned with alternative accommodation, and the fact that the applicants belonged to a vulnerable minority and had a different way of life needed to be taken into account. With regard to Indigenous peoples, the European Court of Human Rights can hear complaints regarding various northern Indigenous peoples, such as the Inuit from Danish Greenland, the Sami in Norway, Finland, Sweden, and Russia, as well as various other Indigenous peoples in the Russian Federation. However, there has been very little progress in the area of Indigenous rights. There have, in fact, been no landmark cases decided by the European Court of Human Rights in favour of Indigenous people, and this could explain why there is very little scholarly interest in examining the possibility of using the court as a way to promote or protect their rights. This is despite the fact that the court is in a strong position to protect their rights. However, the European Court of Human Rights has made comments in relation to Indigenous peoples, which opens up some possibilities for the protection of their rights in the future. Finally, and thank you for bearing with me, covering this monumental arena, can I say that in this very difficult time in our world, the type of dialogue that we are exploring here with you, one of cooperation and communication, is vitally important. We have so much to learn from each other. Thank you.
Muchas gracias, señora McMorrow. Bueno, el presidente del tribunal, don Carlos Carmona, le hará entrega de una medalla de reconocimiento por su participación en esta conferencia.